Welcome to the Deep Dive. Today, we're taking a look at a really central area of law, something that touches on, well, loads of aspects of everyday life. Tort law.
Mm-hmm.
Now, if you're maybe just starting out with law, that term might sound a bit, complex.
Sure, it can seem that way.
But really, you can think of it as the rule book for when someone's actions, or maybe their lack of action, causes you harm, and you might be able to get some kind of remedy.
That's a good way to put it. It's a big part of what lawyers call private law. Sits alongside things like contract law, that's about agreements, obviously, and unjust enrichment, which deals with unfair profits.
Right.
Tort law, though, it's about situations where the law says someone owes you a duty, a responsibility, and they haven't lived up to it, and that failure caused harm.
In this duty, it's not usually something you've signed on a dotted line for.
Exactly. It's mostly fixed by the law itself. And if that duty is breached, the person who's been wronged, well, they generally have the right to seek a legal remedy, usually money compensation, to try and make things right.
Okay. So for this deep dive, we're leaning on, the standard legal textbooks, sort of getting the established view from the experts.
That's the plan.
And our aim is really just to build a solid foundation for anyone new to this. Break down the big ideas in tort law without getting bogged down in every single detail straight away.
Sounds good. Where should we start?
Let's start right at the beginning. What is a tort, legally speaking? How do we pin it down?
Well, different legal scholars have framed it slightly differently. Peter Burks, a very influential thinker, he suggested legal rights tend to come from four main sources.
Okay.
Wrongs committed by others, consent you've given, cases of unjust enrichment, or sort of other miscellaneous events. Torts fit firmly in that wrongs category.
So civil wrongs, not crimes necessarily, though sometimes they overlap, I guess.
Right, and distinct from breaches of contracts you've explicitly agreed to, or those unjust enrichment situations we mentioned.
So it's the law saying, hang on, you had a duty here, you dropped the ball, and it caused a problem.
That's the essence of it. And that duty, that obligation, it's imposed by the law, generally on everyone, outside of those specific contract or unjust enrichment contexts. And crucially, if that duty is breached, and it infringes on your legally protected interests?
Like your physical safety or your property or reputation.
Exactly. Then you, the person owed the duty, can take legal action to seek a remedy for that infringement. Traditionally, there's also been a distinction between torts and wrongs recognized in equity, but that's maybe a deeper cut for now.
Understood. So fundamental duties we owe each other.
Yeah.
Okay, let's get more specific. What about when someone deliberately does something harmful?
Now you're talking about intentional torts. A classic example is false imprisonment.
Right, locking someone up unfairly.
Essentially, yeah. It's the wrongful restraint or confinement of a person without legal justification. It's serious enough that it can also be a criminal offense under the penal code.
Okay, so what are the key ingredients for it to be false imprisonment in tort law?
The main thing is that the defendant's direct act must result in the claimant being imprisoned or confined.
Direct act. What does that mean in practice?
Well, take the case Davidson v. Chief Constable of North Wales. A store detective thought someone was shoplifting, told the police. The police then decided, independently, to make an arrest.
Okay.
The court said the store detective wasn't liable for false imprisonment. Why? Because the arrest wasn't their direct act. The police used their own discretion, their own judgment.
Ah, I see. So just providing information isn't enough if someone else makes the actual decision to detain.
Generally, yes. The defendant's own action needs to be the thing that directly causes the confinement. That independent decision by the police sort of breaks the chain of causation from the informant.
But what if the person doing the arresting is just following orders, like acting as an agent for the defendant?
Exactly. That's the contrast. If the person doing the confining is acting directly on the defendant's instructions or has no independent choice in the matter, then the defendant could be liable. Some older cases like Follister v. Roll and Harnett v. Bond touched on that.
Okay.
And interestingly, there was a dissenting view in a more recent case, Iqbal v. Prison Officers Association. Prison officers took action knowing it would effectively force the governor to keep prisoners confined. They left him no practical choice. The dissenting judge argued that even though it wasn't physically locking the doors themselves, this manipulation, this deliberate action, leaving no alternative, could be seen as sufficiently direct causation for false imprisonment.
That's a really fine line, isn't it? The difference between influencing a decision and directly causing the outcome. Okay, another intentional one. Trespass to land. Sounds simple. Don't go on someone's property. Is there more to it?
There's a key distinction, especially for students starting out: direct versus indirect interference. Direct trespass is what most people think of, physically entering the land without permission, or, crucially, causing an object to directly enter the land.
Like throwing your rubbish into your neighbor's garden.
Precisely. Or placing something there, firing something onto it. That immediate physical intrusion, that's direct trespass.
So what's indirect then?
Indirect interference is where the consequence of your action affects the neighbor's land, but it's not that immediate physical placement. Think about, say, fumes from your factory drifting over.
Or maybe your tree roots growing under their fence and causing damage.
Potentially, yes. Or if you lost control of your car and it ended up on their lawn, these are generally seen as indirect consequences. And usually these sorts of things fall under a different tort, private nuisance, rather than trespass.
Got it. So direct physical intrusion, trespass. Consequences that end up on their land, probably nuisance. That's a helpful distinction. Okay, so we've covered intentional harm. But what about when harm happens accidentally, through carelessness?
Now we're moving into a huge area: the tort of negligence. It's absolutely fundamental.
Yeah, this seems like it could apply almost anywhere.
It does cover a vast range of situations. It's not about deliberate harm, but about failing to take the level of care that a reasonable person would have taken in that situation, and that failure causing harm.
And the starting point is?
The absolute first hurdle is establishing a duty of care. The claimant has to show that the defendant owed them a legal duty to take reasonable care to avoid causing the type of harm that occurred.
A duty owed to them specifically, not just a general duty to be careful to the whole world.
Exactly. That's crucial. It prevents liability from becoming potentially limitless. As was said in the famous Capero case, the duty is generally about avoiding foreseeable harm of a particular kind to a particular claimant or class of claimants.
Foreseeable harm to a specific person.
Yeah.
Okay, so how do courts decide if this duty exists in a new or tricky situation?
There are established tests. In Singapore, the main framework comes from the Spandeck case. It's essentially a two-stage test, building on earlier approaches like the one in Ans v. Merton.
2 stages, what are they?
First stage, you look at factual foreseeability. Was it reasonably foreseeable that the defendant's actions could cause harm to the claimant? And alongside that, proximity: was there a close enough relationship between the parties for the law to potentially impose a duty?
Okay, foreseeability and proximity. What's the second stage?
The second stage involves looking at broader policy considerations. Are there reasons why, even if foreseeability and proximity exist, the law shouldn't impose a duty of care in this type of situation? Think about the wider impact on society, on public services, potential floodgates of litigation, that kind of thing.
Right, so first the specifics of the relationship, then the bigger picture implications.
Yeah.
That policy stage sounds like it could get complicated.
It definitely can be. The courts in Spandeck acknowledge that. The key thing they stressed wasn't to ignore policy, but not to rely only on policy. You need that initial analysis of foreseeability and proximity first. Policy considerations then come in to potentially negate or sometimes support finding a duty.
A balancing act, then. Are there situations where the law generally accepts a duty of care exists? Like standard examples.
Oh, absolutely. There are many established categories. Employers, for instance, definitely owe a duty to their employees to provide a safe working environment.
Makes sense.
And sometimes it gets more complex. There was a case, Chandler v. Cape, where a parent company was found to owe a duty to an employee of its subsidiary, but only under very specific conditions, mainly relating to the parent taking direct control over safety matters.
Interesting.
Solicitors also owe a duty to their clients, obviously, but sometimes, in limited circumstances, they might owe a duty to a third party who is meant to benefit directly from the client's instructions, like a beneficiary under a negligently drafted will.
Okay, so these established relationships often carry inherent duties. What about trying to prevent harm caused by someone else? Do you ever have a duty to protect someone from a third party?
Generally, the common law is quite reluctant to impose such a duty. There's no general duty to rescue someone, for instance. The case, Mitchell v. Glasgow City Council, is quite telling.
What happened there?
A council knew one tenant was threatening another. After a meeting with the council about his behavior, the aggressive tenant attacked and killed the other tenant. The victim's family sued the council, arguing they should have warned him.
And did the court agree?
Largely no. The court focused on the idea of assumption of responsibility. Had the council specifically taken on the responsibility of protecting that tenant from that specific threat? They found it hadn't. So even though the risk was foreseeable and the council was involved, there was no specific assumption of responsibility to safeguard him from the third party's actions.
Wow. So foreseeability isn't enough on its own in those third-party situations. You need something more, like taking on the job of protecting them. That's a tough line. What about public authorities, like the council in that case? Can they be sued in negligence for failing to exercise their powers?
Sometimes, yes, but it's complicated. There might be a common law duty in negligence if they fail even to consider exercising a power they have, or if there's a clear statutory duty to act. However, courts are very wary of intervening in what they see as policy decisions. Things like how resources are allocated, cases like Phelps and Stoven v. Wise discuss these boundaries. It's generally harder to sue a public body for failing to confer a benefit than for causing direct harm.
Right. The courts don't want to second-guess policy decisions made by elected bodies or public officials. Okay, let's shift slightly. What if you have a contract with someone, say a builder, and they also act carelessly and cause damage? Can you sue them under both the contract and negligence?
Yes, you often can. This is called concurrent liability. The big case here is Henderson v. Merit Syndicates. It established that if the facts support claims in both contract and tort, the claimant can generally choose which route to pursue, or pursue both.
So you get to pick the one that works best for you.
Essentially, yes, provided you meet the legal requirements for each claim. This principle is followed in Singapore, too. So, if your builder breaches the contract by using shoddy materials, and those materials also cause foreseeable damage due to carelessness, you might have claims in both contract and negligence. It gives the claimant more options.
That's useful flexibility. Okay, so let's say you've shown there was a duty of care, and the defendant breached that duty by being careless. What's next? You just show their carelessness actually caused the harm, right?
Absolutely crucial. Causation. Did the defendant's negligence cause the claimant's loss?
Yeah.
The basic test here is the but-for test. But-for, you ask, but for the defendant's negligence, would the claimant have suffered the harm? If the answer is no, the harm would not have happened anyway, then causation is generally established. If the harm would likely have happened regardless of the defendant's carelessness, then the negligence wasn't the legal cause.
Can you give an example?
Medical negligence cases often illustrate this well. Barnett v. Chelsea Hospital is a classic. A man drank tea poisoned with arsenic. He went to the hospital, but the doctor negligently failed to examine him properly and sent him home.
Okay.
But the medical evidence showed that even with prompt treatment, the arsenic poisoning was so severe he would have died anyway. So, but for the doctor's negligence, would he have died? Yes. Therefore, the negligence wasn't the cause of death.
Ah, right. The outcome would have been the same.
Exactly. And there are Singaporean examples, too. Vasui v. Tan Tock Seng Hospital. A delay in performing an angiogram wasn't the cause of death because the patient likely would have died before it could have been done anyway. Or Tong Seek Mei Joanne v. Yao Hoke Man Gordon. A failure to fully inform about surgical risks didn't cause the injury because the patient couldn't show she would have refused the surgery even if fully informed.
So the negligence has to be a necessary link in the chain leading to the specific harm suffered. It can't just be negligence plus harm. It has to be negligence causing the harm.
Precisely.
What about tricky situations where the negligence maybe didn't cause the final bad outcome, but it reduced the chance of a better outcome? Like a doctor's delay reduced a patient's chance of survival from 40% to 20%. Can you sue for that lost chance?
That's the very difficult issue of loss of chance. It's been heavily debated. Some argue you should be able to claim for the reduction in chance itself.
Seems fair, maybe.
But the prevailing view, certainly reflected in decisions like the Australian High Court's Tabbitt v. Gell, is generally no. Claimants usually have to prove, on the balance of probabilities, meaning more likely than not, that the negligence caused the actual negative outcome, not just the loss of a chance of avoiding it.
So proving you lost a 40% chance isn't enough. You typically need to show it's more likely than not that the negligence made the difference between survival and death, for example.
That's generally the position, yes. Proving loss of a mere chance is usually insufficient for causation and negligence.
Okay, that's a tough hurdle. Now, thinking about duties again. We talked about duties arising from judge-made common law. What if a duty is written down in an act of parliament, a statute? Can breaking that kind of duty lead to a tort claim?
Yes, it absolutely can. Breach of statutory duty can be a tort in its own right, separate from negligence.
That's right.
Yes. The key question is whether Parliament, when creating that statutory duty, intended to give individuals harmed by its breach the right to bring a private lawsuit for damages.
How do you figure out Parliament's intention if the Act doesn't explicitly say, you can sue if this section is broken.
Courts have to interpret the statute. They'll look at things like, who was the statute designed to protect? What kind of harm was it aimed at preventing? Does the act provide other enforcement mechanisms? It's all about inferring legislative intent.
And is this approach the same everywhere?
Not entirely. It's important to note that in Singapore, breach of statutory duty is generally treated as a distinct cause of action from negligence. That's different from, say, Canada, where breach of a statute is often just seen as evidence of negligence, sometimes called statutory negligence. So for someone studying here, it's key to remember they are usually separate claims.
Interesting distinction.
Okay.
Let's move to another common source of disputes. Nuisances, especially between neighbors, right?
Very often, yes. Nuisance law is primarily about protecting your right to use and enjoy your land without unreasonable interference from others. We mainly talk about private nuisances in this context.
Private nuisance. So things that stop you enjoying your home or land, like loud noise, bad smells.
Exactly. Those are classic examples. And when deciding if something like noise is an unreasonable interference, the character of the area, the locality matters. What's unreasonable in a quiet suburb might be acceptable near a factory. Halsey v. Esso Petroleum dealt with noise and smells in an industrial area.
Right, context matters.
But an important point from St. Helens Smelting Covey Tipping, if the interference causes actual physical damage to your property, the locality argument becomes much less relevant. Damaging someone's property is generally unreasonable, regardless of the neighborhood character.
Okay, so personal discomfort depends on location, but physical damage is usually a nuisance anywhere. Lord Hoffman, in Hunter v. Canary Wharf, also clarified that even sensible personal discomfort is ultimately tied to the land's utility, didn't he?
Yes, he linked it back to the injury to the land itself, the reduced enjoyment or utility value.
What if someone is doing something on their land that affects you, but they aren't trying to be malicious? Does their motive matter?
Generally, no. The case of Bradford v. Pickles is a classic example. A landowner did drainage works that cut off water supply to his neighbor's waterworks. His motive might have been unhelpful, but the court said motive was irrelevant because the neighbor had no pre-existing legal right to that percolating water anyway. The focus is on whether the interference itself is unreasonable, not the reason behind it.
So if you have the right to do it on your land, your bad motive doesn't make it a nuisance, unless you're infringing on a specific right the neighbor already has. Okay, who can actually sue for private nuisance? Just the owner.
You need to have a sufficient interest in the land. Generally, this means being in possession of it. The Hunter v. Canary Wharf case made it clear that mere licensees, people who just have permission to be there, like guests or family members living there but not owning or renting, usually can't sue. You need that possessory stake in the land being affected.
Got it. Tenants could sue, but maybe their kids couldn't independently.
That's generally the idea, yes. The person with the right to possess the land is the one whose right is being interfered with.
What if the nuisance is caused by, say, a tenant or someone the landowner allowed onto the property? Can the landowner wash their hands of it?
Not necessarily. A landlord or landowner can be held liable if they directly participate in the nuisance or if they authorize it. Cases like Lawrence v. Fentigers and older ones like R.V. Moore show that if you authorize an activity on your land knowing it will likely cause a nuisance, you can be held responsible. You can't just turn a blind eye if you have control.
Right. Responsibility follows control and authorization. Okay, there's another specific rule linked to land use. Rylands v. Fletcher. Sounds quite formal. What's that one about?
Yes. The rule in Rylands v. Fletcher. This imposes strict liability without needing to prove fault or carelessness.
Strict liability, so even if they were careful.
Potentially, yes. It applies when a defendant brings something onto their land for a purpose considered a non-natural use of that land, and that thing is likely to do mischief if it escapes. It's dangerous. If it does escape and causes foreseeable damage, the defendant can be liable even if they weren't negligent in how it escaped.
Wow. Okay, so what counts as non-natural use and dangerous?
Non-natural use is a bit tricky, but generally means something beyond the ordinary, common uses of land in that location. Storing large quantities of water or chemicals might qualify, whereas normal domestic water pipes probably wouldn't. Dangerous means likely to cause significant harm if it escapes.
And it has to actually escape.
Yes. The thing must escape from the defendant's land onto the claimant's land. And crucially, the type of damage caused by the escape must have been foreseeable. That was clarified in Cambridge Water Co. v. Eastern Counties Leather. Chemicals seeped from their factory over time and polluted the water company's borehole miles away.
Okay.
The court said that while it was an escape from a non-natural use, the type of environmental damage caused wasn't reasonably foreseeable back when the spillages were happening. So foreseeability of the kind of harm is now a requirement, even under the strict liability rule.
So it's a specific rule for specific situations. Bringing something dangerous onto land, non-natural use, it escapes and causes foreseeable harm.
Hey.
Let's switch gears to reputation. Defamation.
Yes, the tort of defamation protects your reputation against false statements that harm it.
And there's a difference between spoken and written defamation.
Traditionally, yes, slander is generally spoken defamation, while libel is defamation in a more permanent form, usually written or published.
Does that difference matter legally?
It often does. For slander, the general rule is you have to prove you suffered actual damage like financial loss because of the statement.
Oh, really? That sounds hard to prove.
It can be. But there are exceptions where damage is presumed, historically including accusations of serious crime, professional incompetence, having a contagious disease, or unchastity in women, though the UK's Defamation Act 2013 removed the presumption for disease and unchastity.
Okay. And libel, written stuff.
For libel, because it's in a permanent form and potentially reaches more people, the law generally presumes damage to reputation occurred just by the fact of publication. You don't usually need to prove specific financial loss.
So libel is often considered more serious. But what if the damaging statement is actually true?
Truth is a complete defense. If the defendant can prove the statement was substantially true, the defamation claim fails. The Defamation Act 2013 calls this the defense of truth. Substantially true means that the core sting of the allegation is true, even if minor details are wrong.
What if only part of it is true?
That relates to partial truth. If a statement contains several distinct allegations and the defendant proves some are true but not others, that partial truth can reduce the damages awarded for the untrue parts.
Okay. What about opinions? Can you get sued for expressing a negative opinion?
That brings us to the defense of honest opinion, which replaced the older fair comment defense. This protects genuinely held opinions, even critical ones.
What are the requirements?
The statement must be presented as an opinion, not a fact. The person expressing it must indicate, at least generally, the factual basis for the opinion. And crucially, an honest person must have been able to hold that opinion based on facts that existed at the time, or on privileged statements.
So you don't have to prove the underlying facts are all true, just that an honest person could have formed that opinion based on some factual basis.
Exactly. And unlike the old fair comment defense, it doesn't need to be on a matter of public interest anymore.
That seems to offer quite broad protection for expressing views. Any other major defenses?
Qualified privilege is another important one. It protects statements made in certain situations where there's a duty or interest in communicating the information, like fair reports of court proceedings or statements made fulfilling a legal or moral duty.
But it's qualified.
Yes, meaning the privilege is lost if the claimant can prove the defendant acted with malice knowing it was false or being reckless about the truth. There are also provisions around offers to make amends under the 2013 Act.
Okay, so defamation law tries to balance reputation with free speech and reporting. Let's move into something maybe less familiar. Economic torts. What's their focus?
These torts specifically protect your economic or business interests from wrongful interference.
Like someone deliberately wrecking your business deal.
Exactly. A key one is inducing breach of contract. This is where defendant A intentionally persuades or causes party B to break their contract with you, party C, causing you economic loss. The famous case Lumley v. Guy involved persuading an opera singer to break her contract.
And the key is intention. They have to mean to interfere.
Yes, intention is crucial. It's not enough that breach of contract was just a foreseeable consequence of their actions. They need to intend to interfere with the contract as confirmed in cases like Susan Trading.
But how do you prove intention?
Well, knowledge is key. If someone knows about the contract and knows their actions will almost certainly cause a breach, and perhaps that's even their goal, then intention might be inferred. J.T. Strafford v. Lindley touched on this knowledge of likely consequences can lead to inferring intention.
Okay, so deliberate interference with contracts. What else falls under economic torts?
There's causing loss by unlawful means. This is where the defendant uses means that are unlawful in themselves, like committing a crime or another tort, specifically intending to harm the claimant economically, usually by interfering with a third party's freedom to deal with the claimant. The OBG v. Allen case helped clarify this.
Using illegal tactics to hurt someone's business indirectly.
Pretty much. Then there's unlawful means conspiracy. Two or more people agree to use unlawful means to harm the claimant. Interestingly, unlawful means might be interpreted more broadly here than in the single-party tort. Total network is a relevant case.
So ganging up to cause economic harm using shady methods.
And finally, there's intimidation, making a threat to commit an unlawful act which coerces someone into acting or not acting, causing loss to the claimant.
Right, these all seem focused on protecting legitimate business activities from deliberate, unlawful disruption. Now, what about privacy? Huge issue today. Does tort law protect privacy directly?
It's complicated in English law. There isn't one single tort of privacy. But protection is often achieved through a patchwork of existing torts and newer developments.
Like what existing torts?
Well, as we discussed, trespass to land protects your physical space. Nuisance can protect against ongoing interferences like surveillance in some contexts. Defamation protects against false private information harming reputation.
But those seem indirect. Are there more direct protections?
A major step was the Protection from Harassment Act, which created a specific statutory tort of harassment that directly targets persistent, unwanted conduct causing distress or alarm.
Okay, so legislation stepped in there. What about the common law, judge-made law?
That's been evolving too, significantly influenced by Article 8 of the European Convention on Human Rights, the right to respect for private and family life. This has led to the strengthening of the old action for breach of confidence and arguably the development of new torts like misuse of private information.
Misuse of private information.
Yes, often linked to the Campbell v. MGN case involving Naomi Campbell and photos of her leaving a Narcotics Anonymous meeting. Baroness Hale suggested a key question is whether the defendant knew or ought to have known the information was private and there was no legitimate public interest in publishing it.
So the law is adapting, using existing ideas like confidence and human rights principles to protect private information more directly.
That's the trend, yes. Sometimes it's framed as developing breach of confidence, sometimes as a distinct tort of misuse of private information, or even intrusion upon seclusion in some contexts. It's an area still in development.
Very relevant today. Okay, shifting focus again. What happens if someone commits a tort while they're working for someone else? An employee causes harm while on the job.
That brings us to vicarious liability. This is a really important principle.
Vicarious liability, meaning the employer is liable.
Yes, an employer can be held legally responsible for torts committed by their employee, provided the tort was committed in the course of employment. This applies even if the employer did absolutely nothing wrong themselves.
Wow. Why is that? Why hold the employer responsible for the employee's mistake?
There are a few justifications. One is the enterprise risk idea. The business benefits from the employee's work, so it should also bear the risks associated with that work, including the risk of the employee harming someone.
The business creates the risk by operating, so it should cover the downside.
That's part of it. Another very practical reason is compensation. Often, the employee won't have the money to pay damages if they injure someone. The employer is usually in a much better position, often insured, to actually compensate the victim. Vicarious liability helps ensure victims get meaningful redress.
Makes sense from a practical perspective. Okay, we mentioned strict liability earlier with Rylands v. Fletcher. Is that common in tort law, being liable without any fault?
Rylands v. Fletcher is the main example of a common law strict liability tort. Generally, most torts, especially negligence, do require some element of fault, a breach of duty, carelessness, intention. Pure strict liability is the exception rather than the rule in tort law, usually reserved for specific high-risk activities.
Okay, so fault is usually needed, Rylands being a key exception. Now, if a claimant wins their case, proves a tort was committed, what do they actually get? What are the remedies?
The two main remedies are damages, monetary compensation, and injunctions court orders telling the defendant to stop doing something, or sometimes to do something specific.
And the goal of damages is?
The primary goal of compensatory damages is to put the claimant back in the position they would have been in if the tort hadn't happened, as far as money can do that.
So cover their losses.
Exactly. Medical bills, lost wages past, and future compensation for pain and suffering, repair costs for damaged property, things like that. For future losses, like lost earnings, courts have to estimate and then usually discount the amount to reflect inflation and the fact it's being paid as a lump sum now.
Aims to make them whole again, financially speaking. Are there other types of damages?
Yes. Sometimes aggravated damages might be awarded on top of compensation if the defendant's conduct was particularly insulting or high-handed, causing extra distress. In rare cases involving deliberate wrongdoing or outrageous conduct, exemplary or punitive damages might be awarded, not just to compensate, but to punish the defendant and deter others.
Punish them through a civil claim.
Yes, it's controversial but possible in limited circumstances. You might also see gain-based damages, like in conversion cases, where the defendant has to give up profits made from their wrongdoing. Or sometimes license fee damages, compensating for the wrongful use of property as if a license fee should have been paid.
So a range of financial remedies depending on the tort and the harm. One last practical point. If you think you've been wronged, can you just wait forever to sue?
No, definitely not. There are strict time limits called limitation periods.
How long do you typically have?
It varies, but a common period for many torts, especially those actionable per se like trespass where you can sue immediately, is 6 years from the date the tort was committed. For torts like negligence, where you need actual damage, the clock usually starts ticking from the date the damage occurred or became reasonably discoverable.
So the start date might not be when the careless act happened, but when the harm resulted.
Exactly. And figuring out that date can sometimes be complex, especially with latent diseases or hidden defects. But the key message is, don't delay. If you miss the limitation period, your right to sue is generally lost completely. Seeking legal advice promptly is crucial.
Very important practical advice. Okay, finally, let's loop back. We started by saying tort is private law. How does it connect with criminal law? They both deal with wrongs, right?
They absolutely connect. Think of criminal law as punishing the most serious breaches of the standards that tort law often protects. Many actions are both a tort and a crime.
Like what?
Battery hitting someone intentionally is a tort, allowing the victim to sue for damages. And it's also a crime the state can prosecute. Theft involves torts like conversion, but it's primarily prosecuted as a crime. Even causing death through extreme carelessness can be the crime of gross negligence manslaughter, as well as the tort of negligence.
So same bad behavior, but different legal processes and goals.
Precisely. Criminal law aims to punish the offender and protect the public, usually through state prosecution. Tort law aims to provide a remedy, usually compensation, to the individual victim through a private lawsuit, but they often police the same fundamental rights and wrongs. Criminal law often tackles the most deliberate or reckless violations of rights that tort law also seeks to vindicate.
That clarifies the relationship nicely. Well, this has been incredibly thorough. We've gone from defining torts through intentional wrongs like false imprisonment and trespass, the huge area of negligence including duty, breach, causation.
And a nuisance, Rylands v. Fletcher, defamation with its defenses, the economic torts, the evolving landscape of privacy.
Plus, vicarious liability, strict liability, remedies like damages and injunctions, and those crucial limitation periods, and finally linking it back to criminal law.
Phew. It's a lot, but hopefully, as we intended, it provides that solid groundwork, that initial map of the territory for anyone starting out in law.
Absolutely. And we really hope for you, our listener, this deep dive has demystified tort law somewhat and shown you the key principles. It's fascinating, actually, when you start thinking about it, how these ideas play out in everyday life all around us. So we definitely encourage you to notice that. And if you are embarking on legal studies, hopefully this gives you a great launch pad to explore these areas, negligence, defamation, privacy, in much more detail.
Indeed. And maybe one final thought to leave you with, especially as you continue your studies. Tort law isn't static. It changes as society changes. With new technologies, new social concerns, the law has to adapt. So a question to ponder is, how should the law continue to evolve to strike that fair balance between protecting individuals from harm and allowing for innovation, free expression, and the complexities of modern life? It's an ongoing conversation, and understanding these foundations is key to participating in it.